So take a look at those meets and bounds, draw it out, see if it closes. Okay, if there's like a gap between here and here, not a valid legal description. So you might have to add a cause to your complaint that, asks for reformation of the deed. Much like when you're doing a mortgage foreclosure suit, there are times that you have to reform the legal description because it didn't really close or make sense, or it overlapped accidentally over something else. That's the other thing. Take a look at what is described. Does it appear to be overlapping on adjacent neighboring parcels? Because that might be a challenge. Now you've got a potential quiet title suit with a neighbor. And it's not so much, okay, so it's based upon the tax deed, but you've got the challenge of your neighbor thought that was his parcel. Does his parcel's legal description also overlap with yours? Have you both, has your chain of title and your neighbor's chain of title both been paying taxes on this strip of land right here in the middle of the overlap? How does that work out? So those are some of the challenges that you can see with legal descriptions. And then, of course, the practical challenge that I had mentioned with a legal description was when there is property that your client acquires and it's not the typical like brick and mortar house, it's a mobile home. And mobile homes are personal property. They are, they get titles from the Department of Motor Vehicles, just like your car, just like your truck. So those legal descriptions in the tax deed are almost never going to include the VIN and description for the mobile home that's on the property, and you are going to have to take the additional step of getting that information from your client. Send them over to the property and have them go into the mobile home, whatever was left there. Look for that information. What's the model? What's the description? How big is this? What's the vehicle identification number? All of that. And put it in the quiet title suit legal description. Add it in. So here's the description. Here's the shorthand. Here's the longhand version of this. So like what the prior deed stated this was. And you got to make sure that they match up. Like, they don't have to be exact word for word. No, what I mean by match up is that they, as described, are describing the exact same thing. And then you're going to put in also, and mobile home, year, blah, 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 VIN, blah, 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 blah. That permits you to have a judgment in the end that states that this particular piece of personal property that was on your land when you acquired the tax deed, that is related to the land, that is probably being assessed as part of the land, because you'll see mobile home parcels generally get assessed with that mobile home on there, but it's still considered a personal piece of property. And so you're going to have that final judgment. With that, your client can go to the Department of Motor Vehicles and get a deed, a title issued in their name for that mobile home unit. And mobile homes are fairly common in the state of Florida. We have a lot of older individuals from the rest of the country that come and retire. And what is affordable to them is a mobile home. And as a result, when they pass away, it's frequent to have these tax deed auctions as a result of somebody passing away, and it was property that had a mobile home on it. And so you do need to be aware when you're doing your title search for your client. Look at the appraiser's statement of it. See if it's mobile homeland. If it's mobile homeland, go to your client and ask them to get you that information on the mobile home unit so that you can include it in the quiet title suit and make sure that they are then receiving something that they can take to the DMV. So those are some of the legal description errors, issues that might arise. And now I'm going to move on to Constitutional issues. Constitutional issues, due process. That's the big one here. That is the main, most common challenge to a tax deed that you will see. Sure, sometimes you'll see issues arise with payments and assessments and legal descriptions, but in reality, the biggest challenge to your tax deed comes to due process. Did the clerk, the tax collector, the property appraiser, did they give proper notice that there was somebody's land was going to be sold for non-payment of taxes? And did they have the opportunity, with what steps were taken, did they have the actual opportunity to challenge the issuance of that tax deed, to pay for the taxes before they were owed, that kind of thing? So, notice. That's our big focus on this constitutional challenge. What does the clerk have to do versus what due process requires under the circumstances? So here's what we know the clerk has to do. The clerk of court under 197522 of the Florida statutes has to notify, as I've told you, the owner of record, the assessed owner. They have to provide notice to the mortgages of record, lien holders of record, whether it's an HOA lien, a certified final judgment lien. They have to provide notice to the IRS if they have a lien that's recorded, entities that have lien interests recorded in the property. And that also includes certified final judgments from the clerk of court for all of the maybe criminal behavior of the prior owner. Like, all those parties have to get notice. And how do they get notice? The clerk has to send them certified mail, return receipt. If they are out of the country, then the clerk just has to send it out via certified mail. What addresses? What determines the address that the clerk of court has to use for notice purposes? Well, the clerk of court has the duty to send notice to the address as listed on the recorded instrument. This is part of why it is so important for a certified judgment lien holder to put in their actual address, not their attorney's address, their actual address as a prerequisite to it becoming a lien. So certified mail, the listed parties on the statute that have to get notice, and the addresses that are on the recorded instrument. If there are no addresses on the recorded instrument, what does the clerk have to do? Well, that's where you get to due process issues. So, once the clerk has mailed out their notices, first thing that's going to happen is, as you well know if you've sent anything via certified mail, is that you might get it back. You might get it back as undeliverable. You might get that mailing back as unclaimed. You might get that mailing back as unable to forward, right? Or you might get back the little thing where they've signed off and you're like, yes, all right, so that's easy peasy. They got it. We know they got it. Those mailing things are going to create those constitutional challenges or give you an insight as to constitutional challenges that might come up. Because of this, because of the fact that there might not be addresses on, the recorded instruments, the statute has provided for a couple of additional ways in which notice is given. So the clerk is to have the sheriff of the county go post notice on the property of the tax deed sale that's coming up. So there's another way. There's like physical posted notice on the property. The idea being that even if you are the owner and aren't present there, if you have tenants there, your tenants are going to tell you, hey, I got this. What does this mean? Because no tenant or very few tenants are going to look at something and just be like, scrap it and take nothing of it. Anything that's going to make you as a tenant think that you're going to lose where you live should make you run to your landlord. And then the other part is the clerk has to publish a notice of the sale. And this is what we consider constructive notice. Constructive notice is a permitted type of notice in real estate matters. That's why we have what's called the concept of in rem proceedings. It is proceedings affecting the property, and therefore it is considered a type of notice available for real estate matters. So the clerk sends out certified notices. The clerk tells the sheriff to go post notice, and the sheriff will try to also personally serve notice. And then the clerk will publish notice of the sale in a local newspaper twice. So the clerk takes all these steps, does all these things. Your client gets a tax deed. Your client's excited. They're like, okay, I know that I have to do it, or have you file suit to quiet the title to my property. How am I, like what's this going to look like? Based on your assessment of the search, or are we good? Is it going to be easy, hard, difficult? So notice. That's why you're going to look at the tax deed file. That's why you're going to look to see, did the clerk receive any mail unclaimed, undeliverable, unable to forward? And the constitutional challenges and defenses are based on case law. So we've got a couple of cases that I want to go over so that you have an understanding of how to defend these constitutional challenge suits, or how to overcome a defense from the tax deed recipient as to your constitutional challenge. So number one, we've got People's Bank of Indian River County versus State Department of Banking and Finance. This is a Florida 1981 Supreme Court case. And in that case, they've essentially said the legislature, in all its wisdom, has the authority to determine what process and what procedure is going to be established to assert and determine the legal rights of the party and afford them reasonable notice and a fair opportunity to be heard as to something impacting their rights. What that says, in essence, for purposes of you as a real estate attorney in these quiet title matters, is the legislature's actions, the steps that they've created for the clerk, are presumably something that manages to cover due process. Okay, it provides an opportunity for due process to be satisfied. And so it is presumptively compliant with due process. So the presumption then is that the burden is on the person challenging the tax deed to show that the clerk was not compliant, or that the tax collector was not compliant with due process requirements, because the legislature has said, hey, what we've written, the Supreme Court has said, what the legislature wrote, it's good, it's sufficient, it's presumed sufficient. So, next case, we've got Dawson versus Seda. Dawson versus Seda is a Supreme Court case. It's from 1950, and it talks about what is due process. What is procedural due process? Process sufficient? What kind of notice do we have to meet these due process requirements so that people are not just dispossessed of their property without having an opportunity to protect those property interests? Like life, liberty, and the pursuit of happiness. The pursuit of happiness implies property rights. And so it's very, very ingrained into the structure and the setup of the United States that people have the right to protect their property interests. And that requires notice. So Dawson says, notice that is reasonably calculated under all of the circumstances to appraise interested parties of the pendency of the action and afford them an opportunity to present their objections. Okay. Keywords here: reasonably calculated under all the circumstances. So what that should tell you is that as far as meeting notice due process requirements, it depends on the facts. Our favorite word as lawyers, our favorite little phrase, it depends, right? So if I send out a notice that a sale is coming up, and let's say there's only two interested parties, there's a prior owner and a Wells Fargo mortgage. Send out certified mail notices as the clerk. They both sign off on it. Okay. Under all the circumstances, that notice was in fact reasonably calculated to apprise them of the fact that there's an upcoming tax deed sale because they both got their notice. They both signed off on it. They physically, literally, actually received notice. But one of the things that you will find in the tax deed statute that the legislature felt was necessary to put in is that the failure to receive notice of the tax deed sale does not invalidate the tax deed. Failure to receive does not invalidate the tax deed. So simply saying, well, I didn't get it, is not good enough to undo a tax deed sale. Is not necessarily a defense that meets the constitutional requirements to prove that there was a failure of due process. So I want you to keep that in mind while we're thinking of these cases. All right, so constitutional challenges. Notice. Let's continue. So 197502 of the Florida statutes, 197522 of the Florida statutes, they put in the list of the people that are supposed to get a notice, how notice is supposed to be done, the certified mailings, the posting on the property, the publication of the notices, and those are, again, sufficient, deemed sufficient, presumptively, to let interested parties know of what's going on in the case of the property being sold, and afford them an opportunity to pay their taxes, in this case, to prevent the sale from taking place. But it is a rebuttable presumption. One of the biggest cases to come out recently, and it's about 14 years old now, this case, Florida Supreme Court case called Vasilla versus Rosado. And in the Vasilla versus Rosado case, the Florida Supreme Court canceled a tax deed, and the challenge that was presented by the property owners in that case is that they didn't receive notice. They said, okay, we didn't receive notice. Now, of course, the tax deed, the tax collector's office, the clerk of court, they were like, well, we mailed it out to the address that was listed on the deed, on the recorded instrument. And that address that was listed on the recorded instrument is what the Florida statute tells us we have to do. So you're wondering, well, what did the prior owners present to support that argument that due process wasn't met? And here's the key thing, right? Facts and circumstances. The prior owners of the property had filled out the property appraiser's form updating their address. That form was in the hands, available in the record to the tax collector's office, and it was ignored. So property owners actually took an effective step in informing the county of their new address, and the county ignored it when it came down to sending notices of tax liability and sending out notices that the property had become delinquent and sending out notices that the property was going to be sold for non-payment of taxes. So that was sufficient to challenge the perception that the legislative, step-by-step portions were sufficient for notice purposes. No, Vasilla versus Rosado said, hey, they filled out your form for a change of address. They send it to you. You should have known. That's where you should have sent out the notice. And that is why that tax deed got undone. Next case, Evans versus Ireland. Failure to update your address. So this is kind of like the opposing aspect of Vasilla versus Rosado. And this is a Second District Court of Appeals case from 1998. So it deals with like the Central Florida counties, but it's persuasive law for the other areas. And in that one, the prior owner had changed address. They'd moved, right? They had moved. But they had not informed the property appraiser that they had moved. So they hadn't updated the address that was necessary to inform the property appraiser that, hey, you need to send my tax bill somewhere else. And because they had not done this, then their burden to overcome, was this like sufficient, the statutory requirements, were they sufficient for due process purposes? Well, they hadn't overcome that burden to say they constitutionally violated my notice rights. And part of the reasoning in this case, in the Evans versus Ireland case, is that you as a property owner are deemed to know that you owe property taxes. Unless you are, for example, a church that is fully exempt for payment of property taxes. Or you're like a retired veteran with full exemptions from having to pay property taxes under Florida statute. But if you are a standard, regular property owner, whether it's commercial, residential, you know that because you own property in the state of Florida, you have a tax liability in the state of Florida. And so you do have a certain responsibility in making sure that the parties that make those assessments, that send out the notices, that send out the bills, have your address. Very important part there too. So as you can see, part of what you're going to be thinking in these challenges is, if you're trying to undo a tax deed sale, did my client send out notice updating their address? Did they provide anything to the tax collector's office that gave any clue that they had a new address? Did they ever go down and say, hey, I moved, let me give you my new information? Or did they do nothing? Because if they did nothing, well, that's going to make it a challenge for them to actually undo the tax deed based on those constitutional grounds. The next case is Kidder versus Sorelli, and Kidder versus Sorelli is a 5th District Court of Appeals case. In there, it was more about the mailing, how it was returned, and it was returned undelivered. And so if you have mailings, the way that they come back to the clerk kind of puts the clerk on different notice grounds. So if you send it out, it comes back, signed, whatever, you've got the little green card saying that they received it, perfect, great. They've actually received the notice. If, however, that thing comes back unclaimed, it's not saying that that is not their address. It's not saying that that is not a good address for that person. What it is saying is that they didn't bother opening up the mail. So there's a couple of cases out there, but essentially what they've suggested, what has been considered to be notice reasonably calculated, is that if it comes back unclaimed, you as the clerk of court should be mailing out via regular mail the same notice to the same address. You know it's a good address because it's not telling you on the envelope that it's a bad address, so you send it out, regular mail to that same address. If you are representing a tax deed purchaser, you might want to develop a good relationship with that clerk and say, hey, do you guys regularly note on your files when you send out a follow-up, just regular U.S. mail thing when something comes back unclaimed? Almost every clerk in their system notes these little things like that. You should develop a relationship with them where you encourage them to put in those notes if that's what they're doing, because that's going to be a fun thing to discover in a deposition. You don't want to discover that they didn't do anything if it came back unclaimed. So let's say the clerk gets something back that says undeliverable as addressed. What is your job? What would then be notice reasonably calculated? Well, the case law says that if it's undeliverable as addressed, your job as a clerk is to go back and see, okay, like, is this a real address? Like, is it a vacant parcel? And if it's a vacant parcel, what are you supposed to do at that point? Do you have the sheriff go out and try to find something to post notice to? Should you look in the same county for the people and see if they own additional property in that county, and maybe you have a new good address for them? These are the questions that come up, and it's so very fact intensive. And then, of course, if it says undeliverable, unable to forward, that also gives the clerk a heads up that this is not that person's property address anymore, like address for purposes of notice anymore. And so what is the clerk to do? Well, notice reasonably calculated to appraise them based on all of the circumstances is going to give the clerk the following kind of things. So if it is a vacant parcel of land and you get that thing saying undeliverable address, unable to forward, then you are maybe going to want to send the sheriff out and see if there's some sort of structure on that vacant land, or maybe there's a fence that you can post notice on. Go back to the deed, see if there's an alternative address in there for the grantors. Ask the tax collector if they've received any address update notice things, and look through the county. If that person's address was in that county, in your county, look through that county. If the person's address is in another state, in a particular city, maybe do a search in that city of an updated address. However, notice reasonably calculated under all of the circumstances does not mean that the clerk has an obligation to search the entire country for this particular individual. That's not what it means. It's not like you, when you're trying to find a defendant and you do a diligent search and inquiry before you can ever get to constructive notice and publishing for that defendant under a notice of action. The clerk's burden is not to look everywhere for this person. The clerk's burden is to do what is reasonably calculated based on what's known about this individual, this little information that we have about this individual, to try to get notice out to them. But they are not burdened with having to just look for them endlessly everywhere just so that they can publish a tax deed sale, because the property owners have a burden. They have the obligation of knowing that they owe taxes on their property and that they should give notice to the tax collector and property appraiser when they move. So it's a balance. It's a balance, but these constitutional challenges are something that you should become very familiar with and be able to defend against. So, reasonable steps. We've also got Jones versus Flowers. It's a Florida Supreme Court case. It came out around the same time as the Vasilla case. And that one was also dealing with mailed notice, because you'll find that most of these constitutional challenges are dealing with the mailings. What happened to the mailing when it came back unclaimed? What happened to the mailing when it came back undeliverable? What happened to the mailing when it came back as unable to forward? That's why it's so important to look through the tax deed file, because they have the originals of all these things that they mailed out, and it shows how it came back. It shows if it says on the thing, unable to forward. It shows if it says undeliverable. It shows if it says unclaimed. So that gives you a good amount of information as to how is this going to possibly be challenged constitutionally when you go do a quiet title suit for your claim. So in Jones versus Flowers, it says when a mailed notice of tax sale is returned unclaimed, so that's the one where you got an idea that this is a valid address, the state must take additional reasonable steps to attempt to provide notice to the property owner before selling his property. Okay? But they said, comma, if it is practicable to do so. Okay? So if it is practicable to do so, then you must take additional reasonable steps. The most practicable additional reasonable step I've already described is to send the same notice to the same address, but via regular U.S. mail. We know that one of the lazy aspects about just humanity is that if you get certified mail for something, you get that little piece of paper, you might be like, I don't have time to go get it. I don't have time to go to the post office and sign for an envelope, etc. Doesn't mean it's not a good address for you. It just means you're being lazy about it. So if you send it via regular mail, all that person has to do is go to their mailbox, boom, open it up. They no longer have to go sign anything. It's not really a burden, and it is incredibly cost effective for the clerk to do this. And so it is absolutely a practicable step to do. And if you took that additional step as a clerk, it's more likely than not that it's going to be perceived as, satisfying the notice requirements under due process. The court in that case also added this specific language. The process, due process, does not require that the owner receive actual notice before the government take his property, which reflects the exact same language in the Florida statutes. You do not need to have actual notice of what happened to have your due process rights protected. You do not need to have received notice. The government just needs to have taken reasonable steps to get you notice. If you didn't open up that envelope after they sent it via regular mail, that's on you. That's not on the government. If you didn't provide an updated address to the tax collector's office that they could use to figure out where you went for notice purposes, that's on you. If the clerk, however, receives something saying undeliverable or unclaimed, and they don't do anything else at all, well, then that's on them too. That's on them. That's on the government, because it's saying, hey, you might want to try something else. Not looking endlessly, not anything that is impracticable, but you need to do something else to try to get notice out to this person. Not to get them actually notified, but to try to get them notice out. So those are the main challenges that you will see when it comes to filing a quiet title suit and defending against potential issues that arise. Payment, assessments, legal description issues, and constitutional challenges. I'm going to move on to part 4 in a minute, but I did want to discuss something extra that comes up fairly frequently when you are talking to a purchaser at a tax deed auction, and that is, they're going to call you and they're going to say, okay, all right, so I've got a property that I acquired, but it has a homeowners association, or it has a property owners association if it's a commercial area. And they're going to say, and they just sent me this massive bill for like 3 years of delinquent assessments. Should I pay it? The answer is absolutely not. At least in the state of Florida, no. The answer is no. And that is why I always include the associations in my action to quiet title suit, even if they do not have a lien of record. And the reason why is because the management companies for the associations, and generally, if it's a self-managed association too, they don't understand, they don't know that a tax deed wipes out the monetary aspect of the obligation to the association prior to the issuance of the tax deed. So what that means is, if you are a brand new tax deed owner, let's say you've had it for a couple weeks, and the association sends you a thing, notice of intent to file claim of lien, delinquent assessments, blah, blah, blah. immediately call, like that client needs to call a real estate attorney, because your job then is to point out, oh, no. The only thing in an association that survives the issuance of a tax deed, the only aspect that survives the issuance of the tax deed, is the recorded restrictions themselves. So if you are a purchaser at a tax deed auction, you will continue to have to meet the restrictions, the deed restrictions that come with belonging to that association. Meaning, like, you can't go paint the house a weird, crazy color. If it's a commercial lot, you've got to make sure that the kind of tenants that you put in your commercial property qualify for the kind of businesses that are permitted under that association. Those kinds of things. But you are not liable. Your client is not liable for a single monetary delinquency that came due prior to the issuance of the tax deed. And this is important. Prior to the issuance of the tax deed. From the date, like prorated, from the date that they get the tax deed issued in their name forward, they will have to pay and, be liable for regular assessments prorated from that day forward, just like every other property in that particular neighborhood or in that particular commercial complex. But prior to, they cannot collect. And there's multiple cases in multiple jurisdictions in the state of Florida, appellate level jurisdictions, where they've all come to the same conclusion. The fact that restrictions survive does not mean that assessments survive. And it's pretty clear in that same statute that provides for the survivability of restrictions that monetary assessments, monetary liabilities pertaining to those associations are wiped out through the issuance of a tax deed. So yes, definitely send out, letters, etc. Name them as defendants in the suit to protect your client's interests and make sure that your client is not, thinking that they're liable for tens of thousands of dollars in assessments from a prior owner, because here is where it's actually important that this is brand new paramount title from the state. Brand new paramount title from the state as to any private party that is not county or, municipality, and therefore your client shouldn't be paying for that, period. That's why it's very important that even if there's no lien of record for an association, you name them as a defendant in the suit so that you're putting them on notice immediately. Don't even try to send these kinds of absurd claims of lien against my client, because you will be violating the legal superiority of my client's deed. Again, assessments after, that's different. After the fact, after the issuance of the tax deed, that daily assessment or, prorated monthly assessment or prorated quarterly assessment, that'll be the liability of your client. Be very clear with them that having a brand new spanking title does not wipe out their obligations under the restrictions of the association. So if the association says, hey, in order to rent this out to tenants, you've got to hold the property for 2 years. Hey, in order to rent out to tenants, you've got to hold the property for 2 years. Those kinds of things. Those still survive. And what I find practically when I'm dealing with counsel for these associations is that they are very willing to work with you for the most part in terms of consenting to judgment in these quiet title suits. If you add additional language in your judgment that says that, one, you're not going to do anything to impair their ability to try to claim surplus funds if there are surplus funds available for them to satisfy some of that prior delinquency. And two, that your client understands that assessments that come due after the issuance of the tax deed, they still have a liability for, because that's what they're interested in protecting on behalf of their client. And since your client is pretty much has to abide by that obligation, then there should be no reason that your client should object to that in a proposed judgment. All right, so let's move on to part 4. Part 4, undoing a tax deed. So I've talked about the challenges themselves where a party might legally be able to establish the undoing of a tax deed by challenging it based on payments, assessments, constitutionality, or just legal description issues. But the undoing of a tax deed itself is governed by Florida statute. It's governed by 197-602 of the Florida statutes. And that is where it states, what does the tax deed, the person wanting to undo the tax deed, what do they have to do? In addition to showing one of the legal challenges that they have to successfully argue, what do they have to do to get that tax deed undone? So the prior owner, lien holder, whoever the interested party is that wants to undo this tax deed, they have to successfully argue those challenges, and they have to tender payments as described in the statute. Oh yes, your client is not going to be out of luck without a paddle if they were the purchaser of a tax deed and somebody wants to undo it. But what they get back is specifically enumerated in the statute. So your client is going to have to understand that if there's a challenge to the tax deed, they're not going to get all the money back that they may have invested in this property, which is also why it's very, 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 very important that they do the quiet title suit as quickly as possible, as soon as they get that tax deed, so that your client is not investing years of labor, upgrades, improvements, etc. on this particular parcel, only to 3 years down the road have to have the whole thing undone. So 197-602 states the following. If a party is successfully or has successfully challenged the validity of the tax deed through one of those things that we've mentioned, then if one of those challenges is, of course, that they did not pay, or they actually didn't pay the taxes that were due prior to the issuance of the tax deed, then they have to pay the parties that are involved in undoing the tax deed the following. The amount paid for the tax deed, obviously, and all taxes paid upon the land, with 12% interest per year. So if you are a tax deed holder, and let's say you've held the tax deed for 4 years, and they're undoing the tax deed, then you are going to be entitled, if they're going to undo it, they have to pay you what you paid for the tax deed, every other tax payment that you've made for that particular piece of land throughout that time period, and they have to pay 12% interest on that, which is a hefty number. So it is a considerable thing to a challenge of a tax deed. 2, all of the legal expenses, costs involved in the obtaining of the tax deed, the publication, the clerk's fees for issuing and recording the tax deed, what the tax collector paid for doing the search, all of those steps taken, that also has to be reimbursed to the clerk, the tax collector, the property appraiser, by the party who wants to undo the tax deed. And then the third area that gets reimbursed is where it becomes a bit of a challenge for clients, and the big reason why these quiet title suits should be filed very early on, because it'll prevent difficulties that come with having to save all of these receipts, etc., to prove what's in Section C. So Section C says, the person undoing the tax deed also has to pay the fair cash value of all maintenance and permanent improvements made upon the property by the holder under that tax deed. So if you know an investor or a flipper or anything like that, they might not keep all of their receipts for all of the improvements that they've done. They might not keep all the receipts for the maintenance. So maintenance could be, of course, like landscaping, but also could be the monthly assessments that you pay to the homeowners association or the commercial association. Permanent improvements, AC unit, roofing, walls, electrical, whatever updates you did to the property. If your client didn't keep pristine, beautiful, perfect, organized receipts of all of this, proving C to get that money back for your client is going to be a timely and expensive nightmare project for your client. And the longer the time passes between when they got the tax deed and when they asked to file suit to do a quiet title, the bigger the chances that all these projects are going to get done, and the bigger the possibility for not having kept up with all of those records for properly proving, what did I spend on this property so that I can get all my money back now that this person has met the legal requirements for undoing it and they have the money to pay me? Oh my God, I need to have all this organized. So those are the statutory repayment things that go hand in hand with also meeting the legal challenges. Notable challenges to this, it is the court that makes the determination as to the amount owed under A, B, and C. And so it is something in which if you are doing a quiet title suit, if you see these constitutional challenges, and if you see that the challenging party has a relatively deep pocket, then you need to be very honest with your client about the reality of having to pay legal fees and expenses for that party if you keep fighting this. And I say that because 197-602 provides for the prevailing party to get attorney fees and costs. And if you are seeking to undo the tax deed and you've met all of the legal requirements and you have the money to pay all of the other parts, then you're going to be deemed the prevailing party. And as a prevailing party, attorney's fees and costs, that's something they're going to ask for. So if you see in the case, in your assessment, you've got like depositions, you've deposed the clerk, you've got a very good idea of what happened, and things are not looking good in terms of the mistakes that were made, the constitutional challenges in getting this tax deed issued. You need to sit down with your client and you need to explain to them very clearly, even though you had nothing to do with what got done to get to a tax deed. If you are opposing undoing the tax deed, say you really love this piece of land or you had like massive dreams about it, your client was just like over the moon about this piece of land. If you're opposing the undoing of this tax deed, you are going to be seen as the non-prevailing party. And as such, you might be liable in part or in large part, if you are severely challenging this, you're going to be seen as a party that is going to have to pay the legal fees, the attorney's fees of that other side. And let me tell you, when people have the deep pockets to undo tax deed sales, they get the most expensive attorneys who will rack up fees for nonsense, but they're just reasonable enough that a judge is going to sign off on them. So do your client a huge favor, be very, very honest with them about the fact that if they're not the prevailing party, they are going to get stuck with attorney's fees and costs in this. Even if they had nothing to do with the wrongful assessment, nothing to do with the due process violations, nothing to do with an erroneous legal description, nothing to do with accepting payment and it not being properly noted in the tax deed file. Yeah, it's one of those very serious things, whereas like, yeah, sure, you can get all these money back, but all that money that you get back might be nothing compared to the attorney's fees and cost obligations that your client might be liable for.
If you're in a jurisdiction that requires a verification code, please write the following code word down. Silver. SILVER. SLVER, silver.
So do encourage this out of your clients that are regular purchasers of tax deeds if you represent investors in that regard. Please make sure that they have a very good record of all of the expenses and improvements in the property, of the maintenance that they pay for associations, all of this while you are going through the quiet title process and prior to starting the quiet title process. Get in the habit of encouraging them. Okay, did you just buy this taxi thing? Have you bought anything recently? Let's get it filed now. Please keep good track of all of your records. If you're roofing, etc., all of that, make sure you've got your receipts, scan them, save them in a file, put them in a little subfolder for that particular property. Encourage them to do this regularly so it becomes second nature to them in the case of a challenge to their tax deed. And then, of course, one of the things that clients will argue is, okay, well, like I rented the property while I was fixing it, flipping it, etc., and now they're seeking to have it undone. Are they going to try to offset what they have to pay with what I've gained from this property? And the answer is yes. Even though it's not in Section C, it doesn't say it'll be offset. It doesn't say anything like that. Because it is a court of equity, I've seen where judges will be persuaded to offset the Section C costs with what gains the investor made monthly while they held the property. Another issue that does come up with these accountings and the undoing of the tax deed sale that you need to keep in mind is that if your client subsequently sold the property to another investor, not through a warranty deed, but they quitclaimed it over, and then they quitclaimed it over to another investor, and they quitclaimed it over to another investor. Now you have all of these different grantees under the tax deed, so they're entitled to those reimbursements under the statute, but you have all of these different parties, and each one may have done a different thing, and so it's like trying to corral all of these different interest holders along the chain to get reimbursed, to undo a tax deed, and to make sure everybody gets back what they wanted to get back. It becomes a big, big challenge. And if you paid $8,000 for the tax deed, you sold it for $10,000, and they sold it for $12,000, and such forth, the statutory limit is still there. What was paid originally for the tax deed sale, plus taxes paid through the date, plus 12% interest. It's not like, she paid $12,000, so we got to reimburse $12,000, or she paid $15,000, so we got to reimburse $15,000. No, it goes back to the original tax deed. So be aware of that. So, in conclusion, as to this Section 4, what I want you to keep in mind is that there are statutory requirements governed by 197-602 in order to undo a tax deed sale. If you are representing a person who is the prior owner, the prior interest holder, and they want to challenge the validity of the tax deed, they want this undone, they want their house back, they want their vacant land that's been in the family for years back, they need to be ready to have deep pockets that satisfy all of these repayments. And, the longer the time passes, the more that 12% is going to be painful for that party. They are going to have to not only have those deep pockets, but they're going to have to be able to overcome the burdens of why didn't you pay the taxes that you knew were owed on the property, right? Because that's the big underlying thought is you're a property owner, you've got to pay taxes. Why did you not pay the taxes? You're a property owner, you moved addresses, why didn't you update the county of your addresses? You're a property owner, you should know the boundaries of your property. Why are you challenging the legal description on this? Or so forth and so forth. So, those are the aspects you have to take into account when you are the person challenging the tax deeds. And you will notice that for the most part, the parties that challenge the tax deeds themselves are not necessarily the prior owner of record. Those people couldn't afford to pay the taxes, so they're not going to have the deep pockets to undo it, but it's going to be their lien holders. It's going to be their lenders. It's going to be, Bank of America or Candy Smith, the private lender. Those are the people that are going to be interested in preserving their lien interests and are going to be willing to undo the tax deed sale if what is involved in repayment is significantly less than what was secured by their mortgage, by their lien interest. Tax deed sales take place in a field in which there's a lot of discount to the price paid versus the actual market value of the property. If you are a bidder at a tax deed auction and the property is not homesteaded, those beginning bids, those initial bids are going to be, the tax liability, what the tax certificate holder had to pay to satisfy all the other outstanding tax certificates, and the clerk's expenses for holding the sale. So you could get a tax deed for as little as $4,000. You could buy property for as little as $4,000, and that property could be worth $50,000. So if there's a mortgage on it for $40,000, they might see it worthwhile to undo your tax deed sale. On the other hand, if it is property that is homesteaded, the minimum bid is going to be those costs and the half of the assessed value of the property. So if this is a house that's worth $250,000 or is assessed at $250,000, the starting bid is going to be at least $125,000. One is because they don't want people that are homeowners to just have nothing left over, but two, because there's and vested interest in ensuring that these types of properties aren't just sold willy-nilly. And so half of the assessed value, this is a significant amount of money to pay for a tax deed. And because of that, even though that it's half is still a good amount of equity in property. Half is still a good kind of a visual investment in property. And because of these discounted values that exist, there is the incentive for certain parties, certain lien holders to undo these sales if they think, no, I'm going to be able to foreclose on it and get a much better deal. Get much more of my money back this way than the money that's going to be left over for me at the surplus of a tax deed sale as a lien holder. I don't want to have nothing for having lent this person out $80, $90, $100, $150,000. I'm going to get a lot more back. So I'm willing to pay, $20,000 to undo this thing, or $30,000 to undo this thing. So those are the parties that are going to really give you the challenges, and that are going to present the opportunity for attorneys to undo those tax deed sales. And if you are the owner of a tax deed sale, or the owner of a tax deed, or the grantee of a recipient of a tax deed, then you're going to want to make sure that your attorney has looked at the clerk's folder, the clerk's file for that tax deed very early on in the process, so you have a good idea of what challenges might come up. Are they viable challenges? Are they not viable challenges? Not only because that's going to prepare your client's mind for litigation, but it's also going to give your client a good idea of whether they should be putting in a ton of sweat equity and investment into this parcel if it is subject to challenge. So now let's have a conclusion of the things we've covered. I know it's a lot. It's a lot to learn, but I do want you to go into these marketability concerns and tax deed concerns and quiet title suits very well prepared for your clients, because the more that you understand the big picture of how this works, the better you will be able to serve your investor clients in producing marketable title for them. And, you know, in some regards, discouraging them from investing in tax deeds that are very likely to be undone or that have just the right circumstances to be undone. So, conclusion. Tax delinquencies. They are great investment opportunities, not just for your clients, but for yourselves. You know, a tax certificate gives you a great rate of return for a very small investment, much better than you can get at a bank, CD, maybe like randomly at the stock market, because you can get up to 18% rate of return, and so can your clients. So I wouldn't discourage that. Anyone can participate in those Florida tax deed and tax certificate auctions. A tax deed is paramount title, but let's remember, paramount title does not equal marketable title, and a tax deed is not the equivalent of a warranty deed, and a tax deed will require taking steps to render it marketable for the title insurance underwriters that insure warranty deeds. To be a marketable title, you need to file a suit to quiet title for your clients. These suits need to be filed in circuit courts, irrespective of what was paid for the tax deed. And you need to make sure that you have the proper party defendants, and that if your party defendants include federal actors, you are putting in the statutory language that states that that they gave somebody else the authority to sue them, you know, and overcome that sovereign immunity. The action for quiet title can shed light on those challenges to the tax deed, and those challenges that I've covered are issues in the legal description, improper assessment, payment prior to the issuance of the tax deed, and then, of course, the constitutional challenges to these. And timing of when an action to file a quiet title suit is very important in not only preventing expensive litigation for your client, but also preventing the loss of, you know, investment funds for your client, and for prior owners and prior lien holders of record. Because if they don't have, you know, if it's wishy-washy for them on whether they could possibly undo a tax deed sale, and they just don't have the funds for those deep pockets for paying those things, then you need to discourage them from trying to seek to undo the tax deed. So, my name is Natalia Willette, and like I said, I'm a real estate attorney here in the state of Florida. You can find my book on Amazon. The last PDF of my presentation's got my contact information, my YouTube video blog posts, my website. If you have any questions, do not be afraid to contact me. I'm kind of a professor at heart, and so I look forward to assisting you and guiding you in making sure that you get the best results for your client in these tax deed cases. Have yourself a lovely rest of your day, and good luck in your representation of your clients. You can do it, be prepared, and always keep appraised of the latest case law regarding tax deeds.